This just passed today. And if you are a green card holder or even planning to become one, what you're about to hear could directly affect your legal status in the United States, your ability to travel, and even your future path to citizenship. This is not a rumor, not a proposal, and not something that might happen later this year. A new U.S. immigration law was officially passed today, and it quietly changes rules that millions of green card holders have relied on for years without ever realizing those rules could change. Some of these changes take effect far sooner than most people expect, and one of them can resurface decisions you made years ago, even if you believed you were fully compliant at the time. Staying with me until the end of this video could mean the difference between protecting your green card and walking straight into avoidable problems simply because you didn't know the rules had shifted. A green card is more than just a piece of plastic. It represents the legal right to live and work permanently in the United States. And for many people, it represents years of effort, sacrifice, and patience. But here's the part most green card holders are never clearly told. Permanent residence does not mean permanent freedom from oversight. U.S. immigration law is not frozen in time. It evolves with policy priorities, enforcement strategies, and technological changes. And when it evolves, the obligations attached to your green card evolve with it. For decades, many requirements were informal, lightly enforced, or handled only when someone applied for citizenship or traveled for long periods. That era is now ending. The law that passed today reflects a much broader shift in how the U.S. government expects permanent residents to prove, document, and actively maintain their status. This isn't about creating panic, but it is about understanding that the rules you thought you knew may no longer be enough. In the next few minutes, I'm going to walk you through what actually changed, why this law is different from anything we've seen in years, and what you need to do to stay protected in this new reality before ignorance becomes the biggest risk of all. Hi, I'm Timothy, and welcome to Immigration Desk USA channel, and my goal here is to give you clear, verified immigration updates without fear-mongering or confusion, especially when the stakes are this high. Today's update matters because the law that just passed isn't a routine adjustment or a technical footnote buried in policy language. It represents a structural shift in how green card holders are expected to interact with the U.S. immigration system on an ongoing basis. And before you assume this is just another announcement that won't affect your daily life, understand this. What changed today directly alters long-standing assumptions that millions of permanent residents have relied on for years without realizing those assumptions were never guaranteed. So why is this January 2026 law fundamentally different from previous immigration updates? There are three reasons, and missing even one of them could create serious problems later. First, it changes compliance expectations that had remained largely unchanged for decades. In the past, many green card obligations were passive. You lived in the U.S., avoided major legal trouble, updated your address if you moved, and everything else was usually reviewed only when you applied for citizenship or traveled for extended periods. That passive approach is now gone. Second, this law formally introduces new verification and screening systems tied to travel and residency that were previously informal or inconsistently enforced. What used to be case by case is now written directly into law, which means discretion is replaced by standardized review. And third, and this is the part that surprised even experienced immigration attorneys, the law expands how far back the government can look when evaluating your compliance history, even if you believed older actions were already settled. All of this is happening within a much larger immigration environment focused on what policymakers are calling status integrity. In simple terms, that means the government wants immigration statuses to reflect real-world behavior at all times, not just at the moment you apply for a benefit. If you are a permanent resident, the expectation is that the United States is genuinely your primary home, and that expectation now comes with clearer documentation and verification requirements. None of this means your green card is suddenly at risk, but it does mean the margin for being uninformed has shrunk dramatically. And next, I'm going to walk you through the first major change that affects every single green card holder, regardless of how long you've lived in the U.S. or how carefully you followed the old rules. The first major change affects every green card holder, no matter how long you've lived in the United States or how carefully you followed the rules in the past. Under the new law that passed today, green card holders will now be required to actively verify their permanent resident status through a federal system every 24 months. This is completely new. Until now, most people only interacted with USCIS when renewing a card, updating an address, traveling for long periods, or applying for citizenship. Going forward, you'll receive an official notice by mail, email, or both, asking you to confirm basic but critical information, including your current address, employment situation, and confirmation that you have not abandoned U.S. residency. The process itself is expected to take only a short amount of time online. But here's the key point. This verification is mandatory. Ignoring it isn't a harmless oversight. Failing to respond within the required window can trigger a formal status review. That doesn't mean you lose your green card instantly, but it does mean your case moves out of the background and into active scrutiny. For someone who has always assumed their status was secure as long as they stayed out of trouble, this represents a major shift in how permanent residence is maintained. To understand how this plays out in real life, imagine someone who received their green card a few years ago, built a life in the U.S., and rarely thought about immigration paperwork again. Under the old system, that approach worked. Under the new law, when that verification notice arrives, there is no flexibility to delay, ignore, or assume it doesn't apply. USCIS has made it clear that this process is designed to confirm continued ties to the United States, not to catch people by surprise. But the responsibility now sits squarely on the green card holder to respond on time. This is why awareness matters. Something as simple as missing a notice because your address wasn't updated could create unnecessary complications that never existed before. The second major change is where many green card holders are feeling the most anxiety, and it involves international travel. Under the new law, any green card holder who spends more than 180 days outside the United States within a 12-month period will now be subject to enhanced screening when returning. This doesn't automatically mean denial of entry, but it does mean you should expect additional questioning and closer examination of your ties to the U.S. In the past, long absences raised concerns, but enforcement was inconsistent and often depended on the officer you encountered. Now, that scrutiny is standardized. If you cross that 6-month threshold, you should be prepared to clearly demonstrate that the United States remains your primary residence. That includes evidence of ongoing employment, housing, tax filings, family connections, and clear intent to return. For people who travel for work, family obligations, or extended emergencies, this change doesn't ban travel, but it does demand preparation. Walking into a U.S. port of entry without documentation after a long absence is no longer a risk worth taking. Another major change introduced by this new law applies to specific categories of green card holders, and it's something many people will not realize affects them until they miss a requirement. Under the updated rules, certain permanent residents will now be required to submit brief annual reports to confirm that the conditions under which their green card was granted still exist. This applies primarily to employment-based green card holders, investors who obtained permanent residence through programs like EB-5, and individuals with conditional permanent resident status, such as those who received a green card through marriage and are still within the conditional period. These reports are separate from your tax filings and completely separate from the new 24-month verification process. The purpose, according to lawmakers, is to ensure that green cards issued through specific pathways are being used as intended, and that key qualifying conditions haven't quietly disappeared. For most people, this report will be straightforward, but failing to submit it can create delays, trigger additional review, or raise questions later when applying for citizenship. The most important thing to understand is that compliance is no longer passive. If you fall into one of these categories, silence is no longer neutral. It can be interpreted as non-compliance. One of the most unexpected and controversial parts of the law affects people who are applying or plan to apply for U.S. citizenship. In the past, when USCIS reviewed a naturalization application, they focused primarily on the 3-year or 5-year period immediately before the application was filed, depending on eligibility category. Under the new law, USCIS is now authorized to review your entire period of permanent residence when evaluating continuous residence and physical presence. That means travel patterns, extended absences, and compliance issues from years ago can now be re-examined, even if you believe they were already settled or irrelevant. This does not change the basic eligibility timeline for citizenship, but it significantly increases scrutiny for applicants with complex travel histories or long periods spent outside the United States. For someone who received a green card 8 or 10 years ago and is only now applying for citizenship, this change can feel unsettling. Decisions made early in your permanent residence, especially frequent or extended travel, may now carry more weight than ever before. This is one of the reasons immigration attorneys were caught off guard, and it's also why preparation and documentation have become more important at every stage of your immigration journey, not just at the end. So why are so many people calling this new law shocking? It's not because it instantly strips anyone of their green card, and it's not because it creates a new wave of deportations. The shock comes from how quietly and quickly it reshapes expectations that had gone largely unquestioned for years. The first reason is the lack of widespread advanced notice. While this bill moved through Congress, it received very little mainstream media attention until the moment it passed. Many green card holders are learning about these changes only now after the rules are already set. The second reason is the retroactive nature of review. People who traveled extensively years ago believing they were well within acceptable limits may now face questions during citizenship interviews or re-entry screenings about trips they took long before this law existed. And the third reason is the new administrative burden, mandatory verification, annual reporting for certain categories, expanded documentation for travel. All of this adds layers of responsibility that simply didn't exist in this form before. None of these changes are impossible to manage, but they do require a level of organization and awareness that many permanent residents were never told they would need. At the same time, it's important to separate fear from reality because misinformation spreads fastest when anxiety is high. One common fear is that traveling outside the United States will automatically put your green card at risk. The reality is that travel is still allowed, but long absences now demand better preparation and clearer proof of your ties to the U.S. Another fear is that missing a verification deadline means immediate loss of status. In reality, a missed verification triggers a review process, not instant deportation. And USCIS has stated there will be multiple notices and opportunities to comply. There's also concern that this law targets specific nationalities or ethnic groups. That is not the case. The law applies uniformly to all green card holders regardless of where they're from. The real shift here is accountability. If you live in the United States, maintain genuine ties, pay taxes, and treat your green card as a responsibility rather than a formality. This law is not designed to punish you. The risk comes from ignorance, not from compliance, and understanding that distinction is critical as we move forward. Immigration attorneys and policy experts began reacting almost immediately after this law passed, and their responses helped clarify why this moment matters. One managing attorney at a large immigration firm described this law as the most significant change to green card holder obligations in over a decade. Not because it removes rights, but because it formalizes expectations that were previously informal. The consistent advice from legal professionals has been straightforward. Document everything. Maintain clear and provable ties to the United States, and do not assume that old unwritten rules still apply. Policy analysts have pointed out that this shift mirrors systems already in place in countries like Canada, Australia, and parts of Europe, where permanent residence is maintained through ongoing verification rather than passive status. At the same time, immigrant advocacy organizations have raised concerns about the burden this could place on elderly green card holders, people with limited English proficiency, and those living in areas with limited internet access. In response, federal agencies have stated that compliance, not punishment, is the goal, and that support systems will be built into the rollout. The Department of Homeland Security has confirmed that the new 24-month verification system will not go live overnight. Instead, it will be phased in over the next several months with clear written instructions sent directly to green card holders at their address of record. USCIS has committed to providing multilingual support, phone assistance for those who cannot access the internet easily, and a grace period during the first verification cycle to help people adjust to the new process. Officials have emphasized that they are not looking to create gotcha situations or trap people with technical mistakes. What they want, according to their own statements, is active participation and good faith effort. Immigration law professors have also highlighted an important distinction that often gets lost in online discussion. This law does not change the fundamental nature of permanent residence. You still have the same core rights you had before. What has changed is the administrative framework around how you prove and maintain that status over time. And understanding that difference is key to responding calmly and effectively instead of reacting out of fear. Now let's get practical, because understanding the law only helps if you know exactly what to do next. The smartest move right now is to shift from passive awareness to active preparation. Start by making sure you are relying only on official information, not social media rumors or online forums where misinformation spreads fast. USCIS and the Department of Homeland Security will be releasing updates as the new systems roll out, and those updates matter. Next, take a few minutes to review your own situation. Honestly, confirm that your address on file with USCIS is current, because missing a notice due to an outdated address is one of the easiest ways to create unnecessary problems. Look at your green card expiration date, review any upcoming international travel plans, and begin building a simple travel log that records when you leave the United States, when you return, and why you traveled. Then start organizing documents that prove your ties to the U.S. Things like housing records, employment verification, tax filings, bank accounts, and family connections. Keep both digital and physical copies. This isn't about overreacting. It's about being prepared so that if you are ever asked to verify your status, re-enter the country after a long trip, or apply for citizenship, you are ready instead of scrambling. For anyone with complicated travel histories, extended time abroad, or upcoming naturalization plans, this is also the point where speaking with an immigration attorney can bring clarity and peace of mind. Preparation now is far easier than damage control later. Understanding the consequences also helps put everything into perspective without panic. If you miss a 24-month verification notice, the first response is not punishment. USCIS has stated there will be follow-up notices and opportunities to correct the issue. Only repeated non-response over time pushes a case into deeper review. The same graduated approach applies to travel issues. Returning to the U.S. after more than 180 days abroad without documentation doesn't automatically mean loss of status, but it can lead to lengthy secondary screening, difficult questions, and, in serious cases, referral to an immigration judge to determine whether residency was abandoned. For those required to file annual reports, failure to do so can delay or complicate future benefits, including citizenship applications. The key pattern here is consistency. One mistake corrected quickly is rarely catastrophic. Ongoing neglect or intentional avoidance is what creates serious problems. This law isn't designed to trap people who are trying. It creates consequences for those who ignore their responsibilities entirely. And knowing that difference allows you to respond calmly, confidently, and proactively instead of reacting out of fear. To really understand why this law exists, it helps to zoom out and look at the bigger picture of U.S. immigration policy in 2026. Over the past several years, there has been growing bipartisan pressure to modernize the immigration system. Not by changing who qualifies, but by changing how statuses are tracked and verified. Much of the system was built decades ago around paper records, manual reviews, and assumptions that no longer fit how people live and travel today. Government data showed that a significant number of green card holders could not be reached at their address of record, and there were documented cases of people maintaining permanent resident status while living primarily outside the United States for years at a time. At the same time, naturalization applications surged, creating backlogs and forcing USCIS to find faster, more consistent ways to verify continuous residence. Technology finally caught up with policy goals, and this law is the result. It reflects a shift away from the informal honor system toward ongoing digital verification. This isn't unprecedented. Similar tightening happened after major historical moments, such as the changes following September 11th, earlier reforms in the 1990s, and even the original registration systems created decades ago. Each generation of immigration law adds another layer of accountability, and this law is the latest example of that pattern. What this signals for the future is important. This law is unlikely to be the last step. It's more likely the foundation for how immigration statuses will be managed going forward. For green card holders, the message is clear. Permanent residence now comes with an expectation of active maintenance, not just long-term presence. More digital systems, more standardized verification, and more documentation-focused reviews are likely ahead. That doesn't mean your future in the United States is unstable. It means the system now expects clarity, consistency, and proof instead of assumptions. And while that adjustment may feel uncomfortable at first, it's manageable for anyone who treats their status with care. The informal era, where silence meant compliance, is ending. The new era rewards awareness, organization, and timely response. Understanding that shift now puts you ahead of the curve instead of reacting later under pressure. Let's bring everything together because clarity at the end matters just as much as urgency at the beginning. Today, January 23, 2026, a new U.S. immigration law passed that changes how green card holders are expected to maintain and prove their permanent resident status. The core changes are now clear. Mandatory verification every 24 months. Stricter scrutiny for extended travel outside the United States. New annual reporting requirements for certain categories of permanent residents, and expanded review of your entire green card history when applying for citizenship. These are not minor paperwork updates. They are structural changes that shift permanent residence from something passive into something that requires ongoing awareness and responsibility. But here's the most important thing to understand. This law is not designed to punish people who genuinely live in the United States and treat it as their home. If you work here, pay taxes here, maintain real ties, and respond when asked, you are not the target of this law. What you should feel right now is not panic or fear, but awareness. Awareness that the rules have evolved. Awareness that staying informed and organized is now part of protecting your future. An awareness that ignoring these changes carries more risk than the changes themselves. Millions of green card holders will navigate this new system successfully, not because they are perfect, but because they stay informed, respond on time, and take their responsibilities seriously. You can be one of them. If this video helped you understand what just passed and why it matters, take a moment to support this channel so more people don't get caught off guard by these changes. Share this with anyone you know who holds a green card because right now, ignorance is the biggest vulnerability. And if you have questions or concerns, leave a comment below. I read them and I'll continue breaking down updates as USCIS releases implementation details and real-world guidance. Your green card represents opportunity, stability, and your future in the United States. Protecting it doesn't require perfection. It requires awareness, preparation, and action. Stay informed, stay compliant, and stay protected.